Hello and welcome to HRM 140. I'm going to start you with a brief lecture on Chapter 1, which is entitled The Common Law Basis for Laws Governing the Hotel Keeper. Our objectives today are to talk about the development of the rules regarding the rights and liabilities of innkeepers under common law, provide examples of common law that are unique to innkeepers, explain why the laws of two states may differ with regard to essentially the same general issue, explain why two federal circuit courts can reach different decisions while addressing the same type of legal problem, and to describe any legal distinctions that may be made in the terms hotel, inn, and motel. So first of all, we need to determine what common law is. And common law is a body of laws based on legal precedents established by the courts. If we look at this schematic and you think about the three parts of government, you have a legislative branch, that's Congress and the Senate, the executive branch in the middle, that's the president, and the judicial branch on the right, that's the court system. Out of the legislative branch, we get statutory law. Right? The legislation develops statutes or laws. That's the written law. On the right-hand side, the judicial branch interprets those laws. That's the common law. Common law is judge-made law developed by the courts. Then the executive branch in the middle is responsible for enforcing those laws. So when we talk about common law, what we're talking about is that judge-made law developed by the court system. The concept of common law originated in England. Before the court system, the folks that owned the land, your kings, your queens, your dukes, they made the rules and they interpreted their own rules. As the English system moved into the concept of courts, judges would actually travel around the countryside and hold courts, and they would use the customs and common principles of justice to settle disputes between the folks that came in front of them. In order to create some type of consistency, they started to write down the facts of cases and how they decided. And they would actually take these written records back to the Inns of Court in London, and they would be there for the circuit court judges to read and learn about. So an example of common law that applies to what we're studying is that innkeepers were liable as insurers for the loss of guest property and safety. That's an example of common law that bubbled up through the ages from England through the system of judges interpreting common principles. So that provides your answer to number one there. Describe the development of rules regarding rights and liabilities of innkeepers under the common law system. Basically, we took our common law system from the English system, and that developed as the English system moved from landowner rule to a court system. And number two, provide examples of common law rules uniquely applicable to innkeepers. That's what we talked about when we said an innkeeper under common law would be liable as an insurer for the loss of guest property and safety. So let's talk about our third question there, our third objective. Explain why the laws of two states may differ with regard to essentially the same general issue. If we take a look at a map, you can see that each individual state, as we know, has both their own state system with an executive branch, the governor, a legislative branch, their own Congress and their own Senate, and their own state court system. So we have a legislative branch that is making statutory law in each one of these states. So the legislature in North Carolina may look at a problem and create a law that handles it one way, while a neighboring state of South Carolina, their legislature may look at a law and interpret it in an entirely different way. By the same token, once that statutory law is made and the judicial branch is interpreting it, the court system in North Carolina may interpret the same or similar law in a much different way than the court system in South Carolina. And the third way is the executive branch, which is responsible for enforcing it, may decide just to enforce it in an entirely different way. So when answering that question, explain why the laws of two states may differ with regard to the essentially the same issue, it's based on the fact that each state has its own system of government with a governor's office, the legislative branch, and the judicial branch. With regard to state courts, each state court jurisdiction is independent of the other state courts. So a binding decision by one state's court system is not binding on the courts of another state. It is helpful in them making decisions, but it is not binding on them whatsoever. In addition, we have a federal court system. So not only do we have a court system in every one of these states, but then we have a federal court system that is entirely separate. So the state court jurisdiction is about state laws and disputes between citizens from the same state or events that take place in that state. Federal courts, on the other hand, are going to deal specifically with federal laws or disputes between citizens from different states. So let's say that we had a citizen of New Mexico that is suing a citizen from California. You can't decide which state court would handle that situation. And so the two participants in the court case may take that to federal court. That's called diversity jurisdiction. Just for your general reference, this is what the North Carolina judicial system looks like. We have on the lower end the district court and the superior court. Anything that is decided in district or superior court is appealed to the Court of Appeals. And the ultimate authority in North Carolina is the North Carolina Supreme Court. Most states have a judicial system that looks very similar to this. On the federal level, the system looks very much the same. We have district courts on the lower end. There are multiple district courts in each state. A Court of Appeals. There are circuit courts, 12 regionally, including one in Washington, D.C., and then, of course, the United States Supreme Court. In this graphic down here in the lower right-hand side, you can see the three district courts, federal district courts in North Carolina. There's one for the Eastern District in purple, the Middle District, which is generally in orange there, and then the Western District, which is generally in green. So it's divided up into three federal district courts. In this larger map of the United States, you can see the courts of appeals, or the circuit courts of appeals. And as we said, there's 12 of those, including D.C. North Carolina is actually in the 4th Circuit Court of Appeals. And again, that's for the federal court system. So that should help us to understand our competency number 4, explain why two federal circuit courts can reach different decisions while addressing the same type of legal problem. Similar to the issue we discussed in the state system, if the 4th Circuit Court of Appeals, which North Carolina is in, makes a decision on a particular problem, and the 9th Circuit Court of Appeals out here in the West makes a decision on a similar problem, those decisions do not bind each other. So they can make different decisions on the exact same issue. So any disputes between circuit courts are solved in the Supreme Court of the United States. Now on to our competency number 5, legal distinctions between hotel, inn, and motel. In the law, words are very important, and words that can have a certain meaning in common parlance may not have the same meaning in legal parlance. So it's important when you're talking about terms that you make sure that you're using the legal term. So when we talk about hotels, inn, and motels, the law used to recognize a very distinct and important difference between these three types of organizations. A motel was a motor inn where you parked in a parking lot and walked to your room. An inn was usually something that provided food along with lodging. And then hotels were usually the larger buildings with interior hallways. The distinction from a legal standpoint as far as innkeeper is concerned has largely gone away, but it's an important way to describe legal distinction and the importance of words. That's why we do key terms and concepts at the beginning of each one of our learning modules. So the last concept I want to just throw out to you here is the relation between common law, which we've been talking about, and statutory law. Remember, common law is judge-made law, and statutory law is made by the legislature. It could be a state or federal legislature. So the example of common law that we talked about was that an innkeeper under common law is liable as an insurer for the loss of guest property and safety. And under common law, there was no limit to either one of those. Statutory law has developed some limits, so the innkeepers are still liable for the loss of guest property and safety, but the limitation has been brought down to $500. It's different in every state. There may be different federal laws, but that example shows how statutory law can limit common law and the relation between the two. So that's the end of our Chapter 1 lecture. Following this will be Chapters 2 and 3, which are also part of the Part 1 learning module. As always, if you have any questions, don't hesitate to reach out to me, and I hope you have a great day.